efforts of this committee and my colleague. If you're at the table, you can have an influence. If you're not at the table, you're going to be on the table. So why don't everybody just recognize our office is open to constructive criticism, use cases of where the policy doesn't make sense. But if you're in the category of it ain't broke, don't fix it, you're not up with modern times. And I look forward to a good, productive hearing today, and thank you in advance for your productive collaboration as this legislation moves forward.
Thank you, Senator Tillis, and thank you for another positive and engaging hearing. It's been a great experience serving on this committee with you. Today we welcome 6 witnesses to testify about the No Fakes Act. Our first witness is Robert Kinsel, CEO of Warner Music Group, who has a lot of experience. He spent over a decade as YouTube's chief business officer, among a number of other business engagements. Next, we have Twigs. Thank you, Twigs, for joining us today. A singer, songwriter, producer, dancer, and actor who has used AI to help her create and also has had personal experience with unauthorized AI deepfakes. It's great to have a voice present from the creative community. Next, we have Duncan Crabtree Ireland, National Executive Director and Chief Negotiator for SAG-AFTRA, the Screen Actors Guild, American Federation of Television and Radio Artists, a labor union representing 160,000 members who work in film, television, music, and more. Also the voice of the creative community. Then we have Ben Scheffner, Senior Vice President, Associate General Counsel for Law and Policy at the Motion Picture Association, where he specializes in copyright and First Amendment law. Thank you, Ben. We welcome Graham Davies, President and CEO of the Digital Media Association, an organization that represents principally audio streaming companies, platforms like Spotify and YouTube. Mr. Davies also has a history as a musician and songwriter advocate. Finally, we'll hear from Lisa P. Ramsey, professor of law at the University of San Diego School of Law, where she teaches and writes on the intersection of free speech rights and intellectual property law. After I swear in the witnesses, each will have 5 minutes to provide a summary of your opening statement. The senators have your written statements. Then we'll proceed to questioning. Each senator gets 5 minutes for the first round. We will likely have 2 or even 3 rounds of questioning, time and attendance permitting. Witnesses, would you please stand, raise your right hand to be sworn in? Do you swear or affirm that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you all. Let the record reflect the witnesses have been sworn. Mr. Kinsel, you may proceed with your opening statement.
Chairman Coons, Ranking Member Tillis, and members of the subcommittee. I'm Robert Kinsel, Chief Executive Officer of the Warner Music Group. Being here today is something I could not have imagined as a young boy growing up behind the Iron Curtain in communist Czechoslovakia. In 1992, I crossed the Atlantic and attended State University in New York. And there, I met an amazing woman from the Dominican Republic who eventually became my wife, and now we have 2 amazing American daughters. I'm a proud US citizen, and I have deep appreciation for the freedoms at the heart of this great country, having grown up without them. For the past 25 years, I've been a tech and media executive. I joined Warner Music last year after 12 years at YouTube and 8 years at Netflix. Warner Music is home to an incredible array of artists and songwriters who are moving culture across the globe. One of those artists, FKA Twigs, is here with me today. And she's an extraordinarily gifted singer, songwriter, actor, and performer. I would also like to acknowledge and thank Duncan Crabtree Ireland, who led the recent collective bargaining agreement negotiations between SAG-AFTRA and record labels that addresses concerns regarding AI and defends artists' rights. Music has so often been the canary in the coal mine for the broader trends in our society. More than any other form of communication or entertainment, music drives culture and innovation, and that's happening again with generative AI. Today, music companies are helping artists, rights holders, and tech companies figure out this new world, which is both exciting and daunting. It's our job to not only help amplify artists' creativity, but to protect their rights, their livelihoods, and their identities. Across the industry, legends from Roberta Flack to the Beatles have embraced AI as a tool to enhance their creativity. At the same time, generative AI is appropriating artists' identities and producing deepfakes that depict people doing, saying, or singing things that have never happened before. My accent is a vestige to my Eastern European upbringing. You can hear my voice, my identity in my voice. Through AI, it is very easy for someone to impersonate me and cause all manner of havoc. They could speak to an artist in a way that could destroy our relationship. They could say untrue things about our publicly traded company to the media that would damage our business. Unfeathered deepfake technology has the potential to impact everyone, even all of you. Your identities could be appropriated and used to mislead your constituents. The truth is, everyone is vulnerable. Families defrauded by voice clones pretending to be relatives, people placed in pornography without their consent, school children having their faces inserted into humiliating scenes. Some people have spoken of responsible AI as a threat to freedom of speech, but it's precisely the opposite. AI can put words in your mouth, and AI can make you say things you didn't say or don't believe. That's not freedom of speech. We appreciate the efforts of this committee to address this problem, including the No Fakes Act discussion draft authored by Chairman Coons, Ranking Member Tillis, Senator Blackburn, and Senator Klobuchar. Your leadership kickstarted efforts in this area, and we strongly support the bipartisan No AI Fraud Act introduced in the House earlier this year by Representatives Salazar and Dean, and the recently enacted Elvis Act in Tennessee. As the committee moves toward the introduction of a Senate bill, there are 3 elements the bill should contain to be effective. 1, an enforceable intellectual property right for likeness and voice. Each person should be allowed to license or deny that right on free market terms and seek redress for unauthorized uses. 2, respect for an important First Amendment principles, without going any further and providing loopholes that create more victims. And 3, effective deterrence. To incentivize a vibrant and responsible commercial marketplace, we need to maintain consequences for AI model builders and digital platforms that knowingly violate persons' property rights. I applaud the committee for its leadership in addressing these challenging and rapidly developing issues with urgency. Congress should pass legislation this year before the genie is out of the bottle, while we still have a chance to get this right. I look forward to answering your questions. Thank you.
Thank you, Mr. Kinsel. Twigs.
As artists, we dedicate a lifetime of hard work and sacrifice in the pursuit of excellence, not only in the expectation of achieving commercial success and critical acclaim, but also in the hope of creating a body of work and reputation that is our legacy. So why am I here today? I am here because my music, my dancing, my acting, the way my body moves in front of the camera, and the way that my voice resonates through a microphone is not by chance. They are essential reflections of who I am. My art is a canvas on which I paint my identity and the sustaining foundation of my livelihood. It is the very essence of my being. Yet this is under threat. AI cannot replicate the depth of my life journey, yet those who control it hold the power to mimic the likeness of my art, replicate it, and falsely claim my identity and intellectual property. This prospect threatens to rewrite and unravel the fabric of my very existence. We must enact regulation now to safeguard our authenticity and protect against misappropriation of our inalienable rights. 3 decades ago, we did not realize that the internet would embed itself so deeply into the core of our everyday lives. Policies and controls to keep pace with the emergence of the technology were not put in place to protect artists, young people, and those that are vulnerable, and it ran away with us. AI is the biggest leap in technological advancement since the internet. You know the saying, Fool me once, shame on you. Fool me twice, shame on me. If we make the same mistake with the emergence of AI, it will be shame on us. Let me be clear, I am not against AI. As a future-facing artist, new technologies are an exciting tool that can be used to express deeper emotions, create fantasy worlds, and touch the hearts of many people. In the past year, I have developed my own deepfake version of myself that is not only trained in my personality, but that can also use my exact tone of voice to speak many languages. These and similar emerging technologies are highly valuable tools. This, however, is all under my control, and I can grant or refuse consent in a way that is meaningful. What is not acceptable is when my art and my identity can simply be taken by a third party and exploited falsely for their own gain without my consent due to the absence of appropriate legislative control and restriction. History has shown us time again that in moments of great technological advancement, those in the arts have been the first to have their work exploited and in many instances fraudulently commoditized. Soon after, it follows that the general and more vulnerable public suffer the same types of image and voice-related exploitation. By protecting artists with legislation at such a momentous time in history, we are protecting a 5-year-old child in the future from having their voice, likeness, and identity taken and used as a commodity without prior consent. I stand before you today because you have it in your power to protect artists and their work from the dangers of exploitation and the theft inherent in this technology if it remains unchecked. I am here on behalf of all creators whose careers depend deeply on the ability to create safe in the knowledge that they can maintain tight control over their own art, image, voice, and identity. Our careers and our livelihoods are in jeopardy, and so potentially are the wider image-related rights of others in society. You have the power to change this and safeguard our future. As artists, and more importantly, human beings, we are a facet of our given, learned, and developed identity. Our creativity is the product of this lived experience, overlaid with years of dedication to qualification, training, hard work, and dare I say it, significant financial investment and sacrifice. That the very essence of our being, at its most human level, can be violated by the unscrupulous use of AI to create digital facsimile that purports to be us. And our work is inherently wrong. We work together to ensure we do all we can to protect and create an intellectual rights system, as well as protect the very basis of who we are. We must get this right. You must get this right before it's too late. Thank you.
Thank you. Mr. Crabtree-Ireland.
Thank you very much, Chairman Coons, Ranking Member Tillis, and the members of the Subcommittee on Intellectual Property. My name is Duncan Crabtree-Ireland. I'm the National Executive Director of SAG-AFTRA, the country's largest labor union for entertainment and media artists. And I'm here today to testify in support of the No Fakes Act. Our members believe that AI technology, left unregulated, poses an existential threat to their ability to, 1, require consent for the creative use of their digital representation, 2, receive fair payment for use of their voice and likeness, and 3, to protect against having to compete against themselves, their own digital self, in the marketplace. I'm the chief negotiator for the union's contracts, including last year's historic agreement with the major entertainment studios, which was only finalized after the longest entertainment industry strike in over 40 years, a strike that lasted nearly 4 months. The strikes and the public's response to them highlighted that the entertainment industry and the broader public understand that AI poses real threats to them, and they fully support protections against those threats. For an artist, their image and likeness are the foundations of their performance, brand, and identity developed over time through investment and hard work. SAG-AFTRA has long fought for right of publicity laws and voice and image protections. The exponential proliferation of artificial intelligence technologies which allow for rapid and realistic fakes of voices and likenesses in audiovisual works and sound recordings, makes this fight urgent for our members. Enshrining this protection as a federal intellectual property right will ensure our members, creative artists, and frankly, all of us are protected, and service providers provide the same protections to individuals' images, likenesses, and voices that they provide now for other intellectual property rights. These rights should be transferable and descendable just like any other intellectual property or any kind of property someone owns, with durational limitations on transfers during one's lifetime to ensure that we don't enter into an era of digital indentured servitude, just as actress and SAG-AFTRA member Olivia de Havilland fought to establish the 7-year rule to end long-term abusive contracts in the old studio system. Some will argue that there should be broad, categorical First Amendment-based exemptions to any legislation protecting these important rights. There are no stronger advocates for the First Amendment than our members. They rely on their First Amendment rights to tell the stories that artists and other countries are often too endangered to tell. That the First Amendment does not require that the speech of the press, or any other media for that matter, be privileged over protection of the individual being depicted. To the contrary, the courts apply balancing tests which determine which right will prevail. These balancing tests, the depicted individuals protected and rewarded for the time and effort put into cultivating their persona, while not unduly burdening the right of the press to report on matters of public interest or the entertainment media to tell stories. At the same time, these tests help ensure that to create the value associated with the persona they have carefully crafted. With new AI technologies that can now realistically depict an individual's voice or likeness with just a few seconds of audio or even a single photograph, and with constantly evolving capabilities of these technologies, it is even more important that broad categorical exemptions be avoided and that the courts be empowered to balance the competing interests. It's also essential that action be taken to address these harms now. Our members, the public, and our society are being impacted right now by the abuse of deepfake technology, and we must take timely action. Just as one of many examples of the abuse of deepfake technology, during the ratification campaign for our contract after the strike last year, an unknown party on the internet created an unauthorized deepfake video of me saying false things about our contract and urging members to vote against it. Anathema to me as someone who had devoted my life for more than a year to a contract I deeply believe in. There was no federal right to protect me, no takedown right, and tens of thousands of people were misled about something that really mattered to so many of us. It's neither necessary nor appropriate to wait for broader artificial intelligence regulation to be adopted. This narrow and technology-neutral approach can and should proceed expeditiously forward. The companies behind many of these technologies are asking for rules so they better understand the appropriate boundaries on their conduct. The No Fakes Act will provide them with important guidance while helping to ensure individuals are protected from exploitation that puts their livelihoods and reputations at risk. Thank you again for this opportunity to speak today, and I look forward to answering your questions.
Thank you, Mr. Crabtree Ireland. Mr. Scheffner.
Chair Coons, Ranking Member Tillis, members of the subcommittee, thank you for the opportunity to testify today on behalf of the Motion Picture Association and our member studios about legislation to regulate the use of digital replicas. For over a century, the MPA's members have employed innovative new technologies to tell compelling stories to audiences worldwide. From the introduction of recorded sound in the 1920s, color in the 1930s, to the dazzling special effects in movies like this year's Dune Part 2, the MPA's members have long used technology to allow filmmakers to bring their vision to the screen in the most compelling way possible. Artificial intelligence is the latest such innovation impacting our industry. MPA sees great promise in AI as a way to enhance the filmmaking process and provide an even more compelling experience for audiences. But we also share the concerns of actors and recording artists about how AI can facilitate the unauthorized replication of their likenesses or voices to supplant performances by them, which could potentially undermine their ability to earn a living practicing their craft. The No Fakes Act is a thoughtful contribution to the debate about how to establish guardrails against abuses of such technology. However, legislating in this area necessarily involves doing something that the First Amendment sharply limits: regulating the content of speech. It will take very careful drafting to accomplish the bill's goals without inadvertently chilling or even prohibiting legitimate, constitutionally protected uses of technology to enhance storytelling. I want to emphasize, this is technology that has entirely legitimate uses that are fully protected by the First Amendment and do not require the consent of those being depicted. Take the classic 1994 film Forrest Gump, which depicted the fictional Forrest character played by Tom Hanks navigating American life from the 1950s through the 80s, including by interacting with real people from that era. Famously, the filmmakers, using digital replica technology available at the time, had Forrest interact and even converse with presidents, or should I say, former senators, Kennedy, Johnson, and Nixon. To be clear, those depictions did not require the consent of their heirs, and requiring such consent would effectively grant heirs or their corporate successors the ability to censor portrayals they don't like, which would violate the First Amendment. In my written testimony, I detailed some specific suggestions we have for improving the No Fakes draft so that it addresses real harms without encroaching on First Amendment rights. Here, I'll highlight just 4 points. First, getting the statutory exemptions right is crucial, and I want to thank the drafters for getting much of the way there. Those exemptions give filmmakers the clarity and certainty they need to determine whether to move forward with spending tens, even hundreds of millions of dollars on a movie or TV series. If the statutory exemptions are not adequate, some producers will simply not proceed with their projects, a classic chilling effect that the First Amendment does not allow. Second, the bill should preempt state laws that regulate the use of digital replicas in expressive works. Simply adding a federal layer on top of the existing patchwork of state laws would only exacerbate the problems associated with inconsistent laws in this area. Third, the scope of the right should focus on the replacement of performances by living performers. Going beyond that risks sweeping in wide swaths of First Amendment protected speech, which would make the statute vulnerable to being struck down on over-breath grounds. And fourth, the definition of digital replica must be focused on highly realistic depictions of individuals. It should not encompass, for example, cartoon versions of people you might see on shows like The Simpsons or South Park. And lastly, before legislating, MPA urges the subcommittee to first pause and ask whether the harms it seeks to address are already covered by existing law, such as defamation, fraud, the Lanham Act, or state right of publicity law. Often the answer will be yes, indicating that a new law is not necessary. And if there is indeed a gap in the law, for example, regarding pornographic or election-related deepfakes, the best solution is narrow, specific legislation targeting that specific problem. Thank you again for the opportunity to testify today, and I welcome your questions.
Thank you, Mr. Sheffner. Mr. Davies.
Good afternoon, Chairman Coons, Ranking Member Tillis, and thank you to the committee for giving me the opportunity to speak to you today on this important issue. My name is Graham Davis. I'm President and CEO of the Digital Media Association, representing the leading music streaming services. We support the committee's efforts to bring forward legislation at the federal level, which should preempt existing state laws to keep pace with new technology. We join you in the objective of ensuring there are appropriate protections for individuals' likenesses. This is an important issue for us all, and DEMA supports efforts to develop a clear and balanced way forward. Our members benefit from clarity in law and providing fans with licensing complex rights to deliver music to fans. They work closely with record labels and music publishers with whom they have long relationships and robust contracts. This is our common objective. But any new or increased rights should be appropriate and targeted. They should not come at the expense of important freedoms of speech or creative expression. nor should they be overly broad to the point of creating confusion or needless litigation over the true objective of protecting personhood. The No Fakes Act proposes to sweep in a broad range of legitimate replicas and downstream activities within its scope. The current draft punishes good and bad actors of content supply chains on which the streaming industry depends. We are still in the early stages of the application of AI by the artistic community. But we see that the existing practices for taking down illegal or deceptive content continue to suffice in this new context. Streaming services are the last point in the supply chain. Only the originator of the content and the label who delivers it to the services have the information necessary to establish whether the content is legitimate or not. Streaming services do not have any way to know the complex chain of rights behind the content they receive from labels and distributors. To address the harms caused when AI technology is used to imitate a musical artist, a celebrity, or other public figure, we believe the committee's objectives would be best achieved if new legislation was developed from the existing right of publicity laws. This would have a number of advantages. Firstly, there is a body of existing case law on how First Amendment protections can be balanced with the individual's right of publicity. Second, liability sits squarely with the bad actors, those who create the deceptive content and first place it into the public sphere. And thirdly, the focus is on commercial use with actual damages, which we believe are proven to be a sufficient deterrent. Establishing a federal law that preempts the existing patchwork of privacy and publicity laws is both beneficial and necessary. Music streaming is a global industry. We believe that rights pertaining to the person should remain inextricably tied to the individual for the duration of their life. This ensures that each person is always able to retain control of how their voice is used. The discussion draft released by Chair Coons, Ranking Member Tillis, and Senators Blackburn and Klobuchar has been helpful to foster dialogue and encourage all stakeholders to think about these complex issues. I have included more in my written testimony, which is intended to support the next stages of the discussion, and DEMA looks forward to continued work with the committee. Thank you.
Thank you, Mr. Davies. Professor Ramsey.
Chair Coons, Ranking Member Tillis, and other members of the subcommittee, thank you for the opportunity to testify today about the First Amendment implications of the proposed No Fakes Act. I'm a professor of law at the University of San Diego School of Law. I teach intellectual property classes at USD, and my scholarship focuses on the potential conflicts between trademark laws and the right to freedom of expression. The First Amendment of the U.S. Constitution commands that Congress shall make no law that abridges the freedom of speech. Congress generally lacks the power to restrict expression because of its message, ideas, subject matter, or content. This rule is subject to a few limited exceptions for historically unprotected speech, such as fraudulent speech and obscenity. But content-based regulations of speech are generally presumed invalid unless the government can prove the law is constitutional. The No Fakes Act imposes restrictions on the content of speech. It targets the harms caused by the unauthorized creation and dissemination of digital replicas of deepfakes or deepfakes of individuals in recordings that are nearly indistinguishable from that person's actual voice, image, or visual likeness. When the act applies to the use of digital replicas to impersonate people in fraudulent speech or misleading commercial speech, it is consistent with the First Amendment. There's also no conflict with the First Amendment when the act restricts the use of digital replicas and sexually explicit deepfakes without consent if those images or videos constitute obscene speech or child pornography. The problem is that the current version of the No Fakes Act also regulates non-misleading speech that is protected by the First Amendment. Congress must therefore prove that the act satisfies constitutional scrutiny. The law must be narrowly tailored to directly and materially further its goals and not harm speech that's protected by the First Amendment more than necessary. Strict scrutiny analysis may be required when the government is regulating the unauthorized use of digital replicas in political messages, news reporting, entertainment, and other types of non-commercial speech that's fully protected by the First Amendment. As it is currently drafted, I believe the No Fakes Act is not consistent with the First Amendment because the law is overbroad and vague. However, I think a revised version of the law could satisfy intermediate and strict constitutional scrutiny. There are 3 ways that Congress can better protect First Amendment interests in the law. First, it's critical that the law not suppress or chill protected speech more than necessary. The Senate's proposed No Fakes Act does a better job than the No AI Fraud Act in setting forth specific exemptions from liability for certain non-confusing uses of another's image, voice, or likeness. The law can still be improved in certain ways that I discuss in my written testimony. It is also important that Congress not enact a strict liability rule for online service providers that host expression covered by the No Fakes Act. Specific and actual knowledge of the direct infringer's use of an unauthorized digital replica should be required for liability. Online service providers should implement a notice and takedown system to make it easier to remove unauthorized deepfakes that violate the law. Accused infringers must also, though, be able to challenge takedown requests by filing a counter notification with the platform. My second recommendation is for Congress to create separate causes of action that target the different harms caused by unauthorized uses of digital replicas. This includes, number 1, the use of deepfakes to impersonate individuals in a deceptive manner. Number 2, uses in sexually explicit deepfakes. And number 3, uses that substitute for an individual's performance that they typically would have created in real life, such as a performance in a song or movie. These causes of action should have different requirements and distinct speech protective exceptions. My third recommendation is that Congress ensure each provision of the law adequately protects speech interests. Congress can better protect expressive values by allowing the new federal statute to preempt the inconsistent state laws that protect the right of publicity and restrict the unauthorized use of digital replicas. If licensing of digital replica rights is allowed by the Act, individuals should be able to consent for each different use of their digital replica. Allowing others to control a person's identity rights through a broad licensing agreement will work at cross purposes with many of the stated goals of this proposed legislation. It could potentially lead to greater AI-generated deception of the public. It can also stifle the right of people to make a living through their performances and result in the use of a licensing agreement. I encourage Congress to continue to protect the interests of both public figures and ordinary people in the No Fakes Act. And I also encourage you to continue consulting with stakeholders, academics, and attorneys with expertise in this field of law. I look forward to answering your questions as you continue to improve the Act. Thank you.
Thank you. Thank you to all 6 of our witnesses for your preparation, your engagement. I'm going to start with some questions about exploring how AI replicas are impacting individuals and entertainment businesses, and then use a subsequent round to get into your perspectives on specific potential revisions to the No Fakes Act. Mr. Crabtree Ireland, thank you for sharing your personal experience of an AI-generated deepfake. This was in the context of the ratification fight for the most recent contract. Given your experience, should a digital replica right apply to all individuals, regardless of whether they're commercializing their image, voice, or visual likeness? You primarily represent people who make a living, who commercialize their image, voice, or visual likeness. Why should we have this available to everyone?
No, it's a great question, Chairman. And I think, yes, we support a right that's available to everyone. Obviously, Twigs, myself, others, Mr. Kinsel, have explained the impact that this can have on people who make a living and whose career is based on their image, likeness, or voice. But the impacts are so obvious and so real for so many Americans outside of the scope of just a commercialized use. And the example I gave, in my mind, is not a commercial use example. This is an example that could apply to anyone, and the impact is so serious. So, yes, we do support this right on a broader basis, and it should be applicable to everyone.
Twigs, could you help us understand how you're using AI as a creative tool, on the one hand, And then briefly tell us a little bit about your experience with AI deepfakes and what you think the future of your industry looks like if we don't heed your urgent call for us to act.
Well, over the past year, I've been creating an AI version of myself that can use my tone of voice exactly to speak in multiple languages. I've done this to be able to reach more of my fans and to be able to speak to them in the nuance of their language. So I've currently explored French, Korean, and Japanese, which is really exciting for me. It means that even with my upcoming album, I can really explain in depth what it's about creatively. It also allows me to spend more time making art. Often, being a music artist or any artist in this day and age requires a lot of press and a lot of promo, a lot of one-liners. So it means if it's something simple that doesn't really require my heart, I can do a one-liner and give it to people to promote a piece of work. And it's harmless, but ultimately I can spend more time making something that's really meaningful for my fans. And the next question, you asked how
your own
have I
experience
been?
with deepfakes.
Yeah. So there are songs online, collaborations with myself and other artists that I didn't make. It makes me feel vulnerable because, first of all, as an artist, I think the thing that I love about what I do is that I'm very precise. I take my time with things, and it's really what I'm very proud of my work, and I'm very proud of the fact that I think my fans really trust me because they know that I just put so much deep meaning of my North Star into what I do. So the fact that somebody could take my voice, change lyrics, change messaging, maybe work with an artist that I didn't want to work with, or maybe work with an artist that I wanted to work with, and now the surprise is ruined, it really leaves me very raw and very vulnerable. I think that if legislation isn't put in place to protect artists, not only will we let artists down who really care about what we do, that have spent a long time developing themselves, developing the way that we work, but it also would mean that fans wouldn't be able to trust people that they've spent so many years investing in. It would affect us spiritually, it would affect us financially, and it makes honestly, if I'm honest with you, I'm just surprised that we're even having this conversation because it feels so painfully obvious to me that it's hard to even find the language, if I'm completely honest with you.
There are a lot of painfully obviously call out for Congress to act. So your surprise is not unusual. It is broadly spread.
But ultimately, what it boils down to is my spirit, my artist, and my brand is my brand, and I've spent years developing it, and it's mine. It doesn't belong to anybody else to be used in a commercial sense or cultural sense or even just for a laugh. I am me, I am a human being, and we have to protect that.
Thank you. Mr. Kinsel, if I might just briefly, we've seen a steady increase in the quality of deepfakes with songs on streaming platforms that are virtually indistinguishable from talented artists like Twigs. What are the challenges that AI deepfakes are creating sort of long-term for both the music business and for fans, as well as for performers?
So I think Twigs addressed one of those, and no one can do that better than what she just did. I think the second one is that when you have these deepfakes out there, the artists are actually competing with themselves for revenue on streaming platforms because there's a fixed amount of revenue within each of the streaming platforms, and if somebody is uploading fake songs of Twigs and those songs are eating into that revenue pool, there's less left for her authentic songs. So that's the economic impact of it long term. And the volume of content that will then flow into the digital service providers will increase exponentially, which will be harder for the artists to be heard and to actually reach lots of fans. So creativity over time will be stifled.
So as you both put it, there's both a relationship impact, a spiritual impact, a financial impact, a broader ecosystem of creativity impact. Senator Tillis, I turn to you.
Thank you, Chairman Coons. And again, thank you all for being here. Ms. Ramsey, I'm going to start with you and then have others who may have an opinion on it. You mentioned notice and takedown in your comments. This is a strict liability bill in its current form. Some of us think that maybe we have to wade into that. You also talked a bit about having, I guess, that having the individual who's been informed of takedown having.
Somebody challenges your own personal use of your identity online, and they are the one that's the bad actor, but they file a complaint with the online service provider, and the online service provider who wants to avoid liability automatically takes it down. Mm-hmm. That's one possibility. Another would be that the person who is disseminating this image actually has a defense, right? An exception applies to this particular use. It might be news reporting or parody. And so it's critical for the online service provider, the law. Under the copyright laws, my understanding is that once the information is put back up, it stays up unless the copyright owner files a lawsuit. So this is what's great about the takedown and notice procedure is it allows ordinary people to get this off these unauthorized uses off the internet. And I think that's one real benefit of having a notice and takedown procedure and encouraging companies to adopt one. There are some challenges, though, with notice and takedown procedures that folks like Eric Goldman and others have talked about. So it's great that you're talking to interested parties.
Okay. Mr. Kinsel, can you walk me through what rights typically what rights typically are granted to record labels under exclusive sound recording agreement, and are likenesses included in that?
So it's a pretty wide range of rights, anywhere from full copyright right to distribution-only rights, where the copyright remains with the artist, and increasingly so they include likeness as well, because we're, as you can imagine, as we work on open platforms with lots of user-generated content, we are the ones who have staff of people that is working to issue notices, claim the content, take down the content, and increasingly we need the name, image, likeness, and voice rights in order to actually act on that on the artist's behalf with the platforms.
I think you believe that new digital replica rights need to be fully transferable?
Yes.
Why isn't a license enough?
I think it should be at the choice of the artist. The artist should have a choice to either transfer or license.
Okay. Mr. Scheffner, state-level right of publicity laws restricting commercial speech have existed for many decades. They've developed their own case law, and they're well understood. The new digital replica right proposed by No Fakes Act would affect non-commercial speech beyond what most state laws currently cover. Can you explain how novel this proposed right would be in the context of existing right of publicity laws, and how should we consider preempting similar state-level digital replica laws, especially when it's such new territory?
So thank you for the question, Senator Tillis. And you're absolutely right that most state right of publicity laws, which have existed for more than a century, are really limited to commercial uses. That's in advertisements or on merchandise. What Congress is considering doing here is really novel. Although it's sometimes described as right of publicity, we think it's fundamentally different in that it would apply in expressive works like movies, TV shows, songs, which are fully protected by the First Amendment. So there has developed a robust body of case law in the traditional commercial right of publicity context, which says, yes, it applies if you put somebody's face on a billboard or use it in an advertisement on a lunchbox. But it doesn't apply if, for example, you're making a biopic or a docudrama about somebody. You can't use right of publicity law to censor those portrayals. Again, this is a novel form of right, which is going to be subject to heightened constitutional scrutiny, like Professor Ramsey described. Because it applies in expressive works, it's really important up front to provide some clarity to film producers so that when they're about to embark on a project, they know what's allowed and what's not. And if it's too vague, if it's too uncertain, they're going to shy away from using this technology to engage in those sorts of portrayals. Again, that chills speech, and the First Amendment case law says that a statute is vulnerable to being struck down if it chills constitutionally protected speech.
Yeah, which is why we absolutely have to get it right. I think there's general consensus that we have to make progress, but the challenges of all this work being struck down are significant, so we have to do the legwork. Thank you. I'll have a second round.
Great, thank you. Senator Tillis, Senator Huron.
Thank you, Mr. Chairman and Ranking Member Tillis, for bringing this bill before us. And as you say, Mr. Chairman, that the bill has gone through a lot of input from a lot of different groups. And if I listen to your testimony accurately, it doesn't sound as though any of you think that we should not do something that will protect, I like the framing of protecting personhood. Any of you think that we don't need to do anything in this area? Okay, so looking at this statute, then why don't we go down the list very quickly? What do you like most about the current bill? And we'll just start with Mr. Kinsel about the current bill, and what is the most important thing you would want to change, if anything? And if you can just keep your answer really short.
I'll start with what I believe it needs to contain, which is it needs to contain consent for the use of people's name, likeness, and voice to train AI models and create outputs. That's what needs to happen. Second, it needs to contain monetization, which is fair market license that person can exercise through that consent. But in order for that to happen, and in order for all of that to be operationalized by the platforms, we need two things. One, which is provenance of the content that generative AI models are trained on and that they're outputting to be retained, which means they should keep sufficiently detailed records on what they trained on, so that later on, that provenance can be embedded into the watermarks, which are recognized by the platforms on which the content is.
The point is, it sounds like consent is the critical part of this, consent of the creator.
And provenance.
Of the image.
And provenance of the content. Okay. And we are good at tracing provenance on luxury clothing, on cheese, on wine. We should be able to do it on intellectual property as well.
Going down the line? We're talking about this particular bill. Is there something in this bill that you think is the most critical aspect of the bill that you support? And is there anything that you would change in the bill?
I think the most important thing is to put the power on artists. I want to be in control of my likeness, my brand, my legacy. I have sacrificed so many years to be good at dancing, at singing, so much financial input, so much time. And I do it in the name of my legacy. I do it so that one day I can look back at my body of work and say that was me. To be protected in the bill.
Thank you, Senator. I think what I like most about this bill is the fact that it is broader than limiting it to commercial use. The fact is, the commercial use limitation may have worked 100 years ago. A commercial use limitation does not solve the problems that we face today, especially because of generative AI, and we need the breadth that is reflected in this legislation. I think in terms of if there were one thing that I would change in it, I would adopt a durational limitation on transfers or even licenses of these rights during a lifetime. I think may not be as necessary after death, but during a lifetime, I think it's essential in order to make sure that someone doesn't improvidently grant a transfer of rights early in their lifetime that turns out to be unfair to them. And I think there's various standards we could look at for an appropriate duration.
So 70 years is a bit long.
Well, no, sorry, the 70 years, though, is the duration of the right in the one-year-old artist who's granting a transfer of rights in their image, likeness, or voice. There should not be a possibility of licensing that for 50 years, or there should be a shorter, perhaps 7-year limitation on those transfers.
Makes sense.
So, Senator, one thing that we do like about the bill is the First Amendment exemptions. We think they are most of the way there to giving our members the clarity and certainty they need. I think they can be improved a little bit, and we have some specific, fairly technical changes that we recommend. One thing that we would recommend changing is there's currently essentially a no preemption provision. We think it should essentially be the opposite. Just discussing with Senator Tillis this novel law with uncertainties around the first. We think it would be important to preempt all publicity law, preempt state regulation of digital replicas in expressive works like movies, TV shows, songs that are protected by the First Amendment.
Thank you for the question. I think.
Do you mind, Mr. Chairman, if we just continue with the response? Go ahead.
Yeah, building on some of the things said with the draft, the fact it's a discussion draft. I think in terms of the key areas that we want to focus on is where liability sits, and that we would encourage it to be focused on the creator and those that are first releasing the content. We would prefer that it was based around right of publicity laws, the existing body of law, rather than IP. Actual damages rather than statutory damages, and the preemption message.
Professor?
All right, thank you for your question. So what I like most about the bill, I love the specific exclusions from liability, even though there might be some additional revision, and the fact that you're protecting personhood. Although I'll note that state right of publicity laws do sometimes apply to non-commercial uses of a person's identity. The Zucchini case involved use of his entire act in a news report. So that's not a commercial use. And in the comedy, California, the Supreme Court case was applied to an identical kind of rendition of the Three Stooges in a lithograph, which is also not commercial speech. So there are some circumstances where current laws do apply to non-commercial uses of a person's identity, and also false endorsement laws can apply to non-commercial uses, but they have to be used in connection with goods and services, so they might be non-commercial use in goods and services. What should we change? Well, I think there's a tie. You said pick one, but I have to pick two. So first, I think we should have separate with distinct. For example, disclaimer might be targeting deceptive of someone, right? Because it dispels any confusion. But a disclaimer doesn't make sense in a sexually explicit deepfake that's been put out there without consent. You might have different requirements with regard to commercial use, right? If it's just a general publicity, you might have a commercial. Whereas if explicit deepfakes apply to both commercial and non-commercial speech. And then my other part of the tie is the provisions with regard to limits or no limits on the scope of licensing. My concern is that individuals without significant bargaining power at the early stages of their career might sign a contract, maybe a long contract where it has a digital rights provision in it, and sign away the right to their identity for a lengthy period of time and use in any context. And so I would like to see some way for Congress to encourage or require those folks who are negotiating these agreements to perhaps have a specific use authorization for a certain movie, right, as opposed to use of your digital identity in any context, right? Or instead of a lengthy period of time, instead of 50, 60 years, I would say maybe 1 to 5 years. And I'm not an expert in the area of what's a good term, but I think it's critical to make that shorter rather than longer, because a lot of these are not going to have that.
I think, Professor, but it's, well, thank you.
Thank you, Mr. Chair, for your. We've spent working on a and moving. So pleased we are to the hearing stage on this. Now, I represent Tennessee. So it doesn't matter if you're on Beale Street or if you're on Music Row, or maybe you're working with Naxos or one of the symphony distributors. You know, we distribute more symphonic music out of Nashville, Tennessee than we've got gospel, we've got church music, we've of African American. It is there. And we are so protect our crew. See, we the best relations to all of and with deeply on no make this a image like them to exercise their intellectual property. That is important. Mr. Come to you. I appreciate the comment you made when we were visiting, preparing for the hearing. You said we got data wrong, data privacy wrong. We still haven't done data privacy.
Yep.
And we can't afford to get AI wrong. And it's going to require that we take an action. Tennessee's month this act, and much of what we have to I think that's a baseline for a federal action. So I'd like to hear from you, if you will, sir, about the need for
Groundbreaking. We are in a unique moment of time where we can still act and we can get it right before it gets out of hand. The genie is not yet out of the bottle, but it will be soon. And the Blackburn, we got it wrong on privacy. We waited too late. Don't get it wrong. The speed at which this will happen will be afforded by open sourcing of foundational AI models, which everything accelerates exponentially. And therefore, it's imperative that Congress acts this year. Thank you.
You know, we've heard some commentators are talking about, well, you've got existing law when it comes to privacy or to personal property and intellectual property protections. And so you can rest on that existing law, and that is sufficient to go in and get a takedown order on some of these AI fakes. Talk to me about why that is not sufficient.
I mean, today, if you think about privacy, how many spam emails do you get every single day in your inbox? Quite a lot. Your personal information is leaking everywhere, whether it's being sold or whether it's just being taken. It's just not safeguarded properly. When that happens with your face and your voice, it's a whole new game. And for you, and this will happen at a volume that is impossible for every single person to try to personally manage, which means it has to be solved with technology. So it is technology that will unleash it, and it has to be technology that helps manage it. And which is why it's important for us to work with the technology platforms to solve this, and that we have to have a working bill and working law that can be operationalized by all of us. But it's the existing framework is simply too whack-a-mole and doesn't work.
Let me ask you this. Do you, and Mr. Chairman, if I can get one more, be held responsible for unauthorized AI fakes that they're continuing to allow to be distributed?
I think we need to develop sort of conditions that they should meet, and then if they don't, then yes. But there has to be an opportunity for them to cooperate and work together with all of us to make it so. And that, I think, is the detailed work that needs to happen. But when we achieve that, then it will work, and they'll be good actors, and many of them are. So I think it's through that collaboration that we can wrestle this down.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Blackburn, and thank you for your cooperation on moving forward this great bill. I have a whole series of questions I want to ask about potential tweaks, so I'm going to try and move relatively quickly, if I might. Mr. Scheffner, you testified we have to include First Amendment exceptions for uses in works that have public interest or newsworthy value. Some people say that any work involving a celebrity is newsworthy or in the public interest, and that raises the challenge of how we define First Amendment exceptions to ensure they don't just swallow up the rule and permit all kinds of uses that the bill is in fact trying to stop. So I'd be interested in your views on how we narrow that. And Professor Ramsey, how would you craft the First Amendment exceptions to make sure that they don't swallow up the whole bill, particularly with regards to what is newsworthy?
Sure. So, Senator Coons, we've talked to your staff, which I have a great relationship with, have talked to other stakeholders and listened to the concerns that have been raised about, well, maybe these exceptions are overbroad and they could somehow swallow the right itself. We've listened and we've suggested tweaks to make sure that those types of exceptions do not apply if the use of the digital replica is deceptive. Fraud, we don't support fraud. Fraud is not protected by the First Amendment. It should not be allowed. Just one, but one other thing I would just say is that these types of statutory exemptions have been routinely included in state right of publicity laws over the last 25 years or so, since the late 90s. And one thing that we've seen, or that we haven't seen, is this type of abuses of those exceptions. They've worked very well in separating out the uses where you should need to get permission, again, to put somebody's face on a billboard or on a lunchbox, versus the biopics.
Got it. Professor, briefly.
Christine Farley and I just recently wrote a paper about how we can balance trademark and free speech rights when someone uses a trademark in an informational or expressive way, like a news report, entertainment, things like that. And I think our proposal in that context might also work here. So as you mentioned, right, some of these kinds of uses can actually be bad, right, impersonation, et cetera. So one approach would be to, in addition to listing out these potential defenses, would be to say if this is an informational or expressive use that is a false statement or false representation, so you actually say this is a certain celebrity when it's not, or a certain teenage girl when it's not, that would be actionable still, even though it's, there's some argument that it's expressive, or if this use is likely to mislead a reasonable person about the source of the message or the speaker's identity. And so that way you would be able to at least have courts consider whether it's an information or expressive use, but also the safety valve that if it's really causing harm because it's deceptive, then you can still regulate it.
Understood. Mr. Davies, today you raised concerns the bill lacks a mechanism for showing or demonstrating your members had knowledge. Should we incorporate a notice and takedown structure? If so, should it be the DMCA's notice and takedown provisions? Is there another mechanism you'd urge us to consider for knowledge and for constructive knowledge?
Thank you for the question. In terms of the current situation, our members are handling, they're the leading streaming services, so they're handling the majority of the music streaming consumption, and the processes are working very well. I think the example that you've used and the other Drake example, which is a common one, there's been no challenge there in taking down the content expeditiously. So we don't see our members needing any additional burdens or incentives here, but we do understand that the committee is keen to look at if there is to be secondary liability, we would very much seek that there be a safe harbour for an effective takedown. I think the DMCA notice and takedown process we don't see as being a good process for here. It was designed for copyright, and we obviously have our position in terms of seeing this as a different set of rights. That said, our members absolutely can work with the committee in terms of what we would think would be an effective notice and takedown, and building on some of the points the professors made there in terms of it's really essential that we get specific information on how to identify the offending content so that it can be removed efficiently. We need information on the notifier and in terms of why is the content offending, on what basis, and also that information on the notifier so that if there is an objection to the notification, that can take place.
Two more questions. I want to talk about preemption briefly, Professor, if I might. Several witnesses have described the existing state right of publicity laws as a difficult to navigate patchwork. Should our bill broadly preempt state laws or limit preemption to those state laws governing uses of unauthorized digital replicas?
So I teach right of publicity law and trademark law and intellectual property survey, and every year I teach it, I think we really need a federal right of publicity law, right? The state laws are so different, and if you go to Jennifer Rothman has this great blog which talks about all the different laws, and then even within a state, the statutory provisions have different rules than the common law provisions.
I take it your answer is yes.
Well, yes. So I'm just building it up. Yeah. So yes, we need preemption, right? But the challenge, right, is obviously Congress. You're doing a great job trying to get this right, and so you get it right, and then you preempt state laws, and that simplifies everything for litigants, for judges. Instead of having to figure out which law is going to apply in a particular, there's right now forum shopping going on, right? People are going to file suit in whatever state's going to be best for their interests, and so if you have, so yes, we need preemption is a great idea.
The discussion draft has a 70-year post-mortem provision. It's modeled after the Copyright Act. Post-mortem rights are important, but we understand 70 years is a long time, especially for individuals who don't commercialize their image, voice, or likeness. I'd be interested, jump ball, several of you, perhaps Mr. Scheffner first and then others. Should post-mortem terms be longer for individuals who commercialize image, voice, and likeness? Should they be limited? Should they be reviewed and re-extended every decade or so? Like, how would you handle post-mortem rights? The draft has 70 years post-mortem, and some of you have enthusiastically supported that as part of your creative legacy. Others have raised concerns. Mr. Scheffner, you kick us off, and we'll do this one quickly.
Sure. So we view this, again, through the lens that this is a content-based regulation of speech. And as Professor Ramsey said in her opening statement, a content-based regulation of speech needs to be justified by a compelling government interest that is narrowly tailored to serve that interest. And what we have said is that as for living professional performers, use of a digital replica without their consent impacts their ability to earn a living. You have a compelling government interest in doing that, in regulate job preservation, justification goes away. And I have yet to heard a compelling government interest in protecting digital replicas once somebody is deceased. So I think there's going to be serious First Amendment problems with extending a right that applies in expressive works post-mortem.
Any other witnesses think preserving the legacy and property rights of an individual is worthy of some protection? Professor Ramsey and then Mr. Crabtree-Ireland.
So this is not going to shock you, but I'm going to say it depends on the goal of the law, right?
You
so if
really
we're
do belong as a professor.
So,
Great.
so if we're talking about a law that's regulating deceptive uses of someone's identity, if we're talking about a law that's governing sexually explicit deepfakes, it seems to me that it's fine to have a post-mortem right, like a long term, possibly, right, maybe life plus 70. If we're talking, though, just about protection of a broad federal right of publicity, maybe not so much. And I haven't written in this area, but I would recommend looking at the works of people who have. Mark Bartholomew, Jennifer Rothman, I think, is working on a paper, et cetera.
Mr. Crabtree-Ireland.
Thank you. I mean, to me, it's shocking that anyone would think that this right doesn't deserve to be preserved and protected after death. I mean, for all the reasons that Twigs stated about how personal this is, it's an economic right, it's a personal right, and it's something that has real value. And so why that should somehow dissipate upon death and make itself available to big corporate interests like the ones represented by some folks here, that doesn't make any sense. I would argue that there shouldn't be a 70-year limitation at all. This right should be perpetual, and the reason why this right should be perpetual is that every one of us is unique. There is no other Twigs, and there never will be. There is no other you or any of us. This is not the same thing as copyright. It's not the same thing as we're gonna use this to create more creativity on top of it later. This is about a person's legacy. This is about a person's right to give this to their. So from my perspective, this is an intellectual property right that deserves protection. It should absolutely be protected after death. And I'm waiting to hear a good reason why it shouldn't be, to be honest with you.
In perpetuity, not at all. Mr. Kinsel, see if you can help us bring this home, and then
I will make this very brief for you. I agree with Mr. Duncan Crabtree-Ireland 100%.
Thank you all for that. Twigs, would you like to make a comment on that? Forgive me.
I was going to say that I've worked so hard throughout the whole of my career, and when I die, I would like all of everything that I've created to go to my family and my estate that will have clear instructions of the way I want to preserve my history and all of the art that I've created.
Thank you. Senator Blumenthal.
Thank you very much, Mr. Chairman. I got off a plane about 20 minutes ago coming from Connecticut, so I do apologize for missing the bulk of the hearing. As you may have heard, we had no votes yesterday, so today was a partial day off, and I had plans in Connecticut. So I am grateful to all of you for being here, and we are very, very hopeful that you're in good health and that you're going to continue creating, and I'm a big fan of your work, so thank you for being here particularly. Thank you, Mr. Chairman, for having this hearing, which focuses on a bill that you're going to introduce. I'd like to be added at the appropriate time as a co-sponsor. I'm a strong supporter, and I believe that there ought to be a federal right for people whose image and voice are used without their consent, whether it is an actor or a songwriter or a singer or an athlete. What is shared here is a right in one's own likeness and creation as a person, an individual right. And I think there ought to be a right to take legal action under that right. A right without a remedy is unavailing, as we know from our first year in law school. Which for me was quite a few years ago, but I've seen it repeated again and again in real life as a prosecutor, as an advocate, as a litigator. But I'd also like to focus on a complementary remedy which could be watermarking or identification, attribution, giving credit, not just the deep fake and the right to recover as a result of use of it without attribution or credit, so to speak, without a watermarking, but also that kind of identification, public crediting of a work. And I'm asking not only in the abstract, but I had a different subcommittee of the Judiciary Committee. It's called Privacy, Technology, and the Law. The ranking member of that subcommittee and I, Senator Josh Hawley of Missouri, have set forth a framework. It's the most comprehensive bipartisan framework right now, and we should do more adopting the kind of measure that Senator Coons and others have proposed. But it would provide a requirement for watermarking, as well as an entity to oversee licensing, mandatory licensing, risk-based of AI models, and other measures like transparency and so forth. It's a more comprehensive approach. But my question is really focused on watermarking. Maybe you can tell us, let me ask all the witnesses, how watermarking can complement rules requiring permission to use someone's likeness or voice or creation in a deep fake or an impersonation, or simply using it without permission.
Maybe I'll take it. Thank you for all of your work on this important issue. I think, without attribution achieved through watermarking, we won't be able to operationalize what we're talking about here today. So you're focusing on absolutely the right issue. And I think the important part in this is to determine the provenance of content that's being displayed, the degrees of similarity to its original, to the original. And then it is up to the rights holders, whether it's artists, music companies, movie studios, etc., to then negotiate commercial relationships with the platforms, separate and aside from the laws and how it all works, using all of those mechanisms. We've actually done this when I was at YouTube. This is precisely what we have done with user-generated content. We've just done it in the copyright scheme, where it was the exact content referenced. And so we built a whole framework around that. This is merely that on steroids, adopted for the AI age, with many more shades of gray and much more speed. But it's really just upgrading that. But the framework exists. It has been developed by companies like YouTube, which is best in class in that. And therefore, I'm hopeful that we can take it further and apply that to AI as it relates to voice and degrees of similarity, using watermarks to label content and carry the provenance of it.
Thank you.
I mean, I can only really talk from personal experience that in the last 6 months, I had 85 of my songs leak online, which was basically the whole of my experimentation for my next album. It was really scary because I felt that it's like having the whole of my notepad, I guess, of all my ideas being put out to the whole world before it was ready. But on the flip side of that, I felt very secure because I was able to call up my label and say, hey, this has happened. And immediately they could go and take it down, and it just disappeared, and now you can't find it. So I think that watermarking, it would protect artists, because then we'll have a point of call to go to say, this has happened, and immediately whatever's been leaked online or put online can be taken down. But one thing I will say is that the thing that's really scary is once something is out in the world, we can't take it back. So if someone uses my likeness and says something offensive or says something harmful, people might think that that is me. And we've all seen in the news when someone does something wrong and the big story is like the front page, but then you think, oh no, they actually didn't do something wrong. It was a mistake, and the rewrite of it is so small. And I think that's the thing that I'm scared about, is even if something does get out in the world that's not me, it's the reputational damage that it will do and the financial and cultural harm that won't be able to be amended after the fact.
Very good point. If the chairman would give me a little more time, I'd be interested in the others to answer. Thank you.
Thank you. I agree with Mr. Kinsel on the value of watermarking and other tools as well. C2PA, the coalition is working on that. But I also just want to caution, especially in deepfakes, it was mentioned earlier, the idea of disclaimers, solving problems there, or the ideas of watermarking, solving problems there. We also have to make sure that tools that we use to protect against abuses of these technologies are realistic. And so expecting viewers of content online to read deeply into captions to find disclaimers or things like that, that doesn't really solve this problem. So I hope as the committee considers what to do, it's not enticed into thinking that that type of solution actually solves the problem. It needs to be more front-facing so that the message that's delivered is received by all those who view it.
So thank you for the question, Senator Blumenthal. As Mr. Kinsel was talking about in the copyright context, watermarking has proved useful in certain contexts. I think he was referring to YouTube's Content ID system, which has been a great help in reducing the presence of pirated material on that platform. I would just say, again, our experience from copyright law, though, is it's not a silver bullet. It sometimes can help identify the original source of pirated material, but just because it's out, just because it has a watermark on it, it doesn't stop it from being further disseminated, et cetera. So there's really no silver bullets in this context.
Thank you for the question. I'm going to build on things that have already been said. I think Robert talked about the partnerships between the services and the rights holders. These are absolutely essential. This is where the content comes from for the services. So we're very reliant on the data, on the metadata that exists. I think it would be true to say that data in the music industry already have significant challenges. But these are challenges we work on together.
Thank you. Professor?
So I'll incorporate by reference everything that's been said before, but then also say that I think someone using a digital replica to impersonate someone or basically put out a sexually explicit deepfake, they're not going to use this kind of technology, so it's not going to help in certain circumstances.
Yeah, and I meant this, I think I used the word complementary. If not, I meant to say complementary. It's not I didn't mean it as a substitute. So I take all these comments as very helpful and valid. Thank you, Mr. Chairman.
On behalf of the chair, Senator Klobuchar. Char.
Thank you very much. That was an AI attempt. I know it was. Kind of failed, kind of close, not quite. Okay, Professor Ramsey, since you ended there, I'll pick up where you were about some of these, and some of the other witnesses mentioned about this deepfakes and how some of these things, whether it's sexually explicit images or whether it is the political robocalls or videos or ads, and I wasn't going to start this way, but it makes sense here because of what you just said. To me, some of this, we just have to get off there. They're not going to be able to listen to a major candidate for president for 3 minutes and then then look and see a label. And I think that in other countries, that's what they've done. That's why Senator Hawley and Senator Coons and Collins and a number of other senators have come together and marking up this bill along with a labeling bill in the Rules Committee on Elections. Could you talk about why that kind of targeted approach to some of these like hair on fire things is very important given the timing of all of this?
Well, as you can expect, I love the fact that you're working on these targeted laws. But again, one of the things we need to do is protect ordinary people from impersonation. Over Thanksgiving, someone called my dad when I was standing right next to him. It sounded just like my brother, and he said he was in jail, and he needed money to get out of jail. And my dad was not duped by this, but the fact some people have been, as the senators have noted. So I think it's a great idea, but I think that we still need the more broad act to deal with these kinds of issues for folks that are not politicians, et cetera.
Exactly. And my state director's son is in the Marines, and her husband got a call where it was an impersonating that scraped his voice. They didn't know where he was stationed. So we're going to see all of this deployed against military families as well. Really all these kinds of scams. So it's going to be, I see this, heaven of some of the great uses, especially in healthcare of AI, but then there's the hell part. And that should be our job to try to put in the guardrails in place, which is why I'm so honored to be working with Senator Coons and Tillis and Blackburn on this bill. So one of the things that interests me during the testimony, you, Mr. Scheffner, and Mr. Crabtree-Ireland, you kind of got to this, but both the No Fakes Act and this election bill include exceptions for the use of digital replicas to ensure the bills do not chill speech protected by the First Amendment. Could you talk a little bit more as we look at how we can write these in a way, as I have tried with exceptions for satire in the elections bill with Senator Hawley, how we can do this to ensure that common sense safeguards do not chill protected speech and that this is upheld in a court?
Right. So, Senator Klobuchar, I just want to say, agreeing with Professor Ramsey, that I think your approach of having specific legislation on pornographic deepfakes, other legislation on election-related deepfakes is really the right way to go. When you have a broad bill that essentially says you need permission to use digital replicas and then let courts kind of sort it all out, that's where you get into trouble. And you have an overbroad bill that is going to necessarily end up encompassing protected speech, makes it vulnerable to being struck down on over-breath grounds. So these kinds of exceptions, I think, are specific to the type of legislation. In the world of movies, our studios, the studios that we represent at the MPA, make a lot of movies that are based on or inspired by real people and events. Went through this morning, last 5 years of all the Best Picture nominees over the last 5 years, approximately half are based on or inspired by real people and events. Our studios want to make sure that legislation like this doesn't interfere with their ability to do that. When you're talking about, say, non-consensual pornographic deepfakes, you don't need those exceptions for biopics and satire and parody. That stuff is bad in almost every circumstance you can think of. And I think this narrow, targeted approach is really the right way to go.
Okay, so Mr. Duncan Crabtree-Ireland, you got the best long name in the world.
Thank you.
Could you talk about maybe at risk, sitting next to one of them right there with twigs, and how do you believe we should balance that?
Absolutely. I think we all agree that that obviously the First Amendment has to be protected and that expressive speech is important. I think the exceptions that are written into this discussion draft now are not that far off, but I think it's important that they not be expanded upon, nor that they be broader than necessary, because the fact is we can't anticipate what this technology is going to do tomorrow. We cannot anticipate every iteration of this, and while there are certain specific uses or concerns that are being addressed by legislation like the legislation you've referenced, there is a broader need for protection. The example I gave in my opening statement is one. Twigs has given examples as they applied to her. And so we do need to have that proper balance. And I am concerned that we are only looking at one side of the First Amendment consideration here. The other side of the First Amendment consideration is the right that each of us has to our own freedom of speech, to be able to communicate our ideas, to associate ourselves with ideas that we want to associate with, and not be associated with ideas we disagree with. And that is being really trampled on right now by this unfettered ability of people without a federal right to do things like the deepfake I experienced, that she experienced, et cetera. And so I do feel like the committee is going to have to work on defining these exceptions, making sure they are no broader than necessary to keep the legislation viable, but also to make sure it doesn't swallow up the rule, like the chairman said. If we make them so broad that they swallow up the rule, then all of this work will have been for naught. And the reality is, today is not like 10 years ago. It's not like 30 years ago. This technology is fundamentally different, and what it can do with all of our faces and voices calls out, it screams out for a remedy that's actually effective.
Mm-hmm. And do you see, and maybe anyone, Twigs, any of you, Mr. Kinsella, want to get this need for a national standard, just because Senator Blackburn's worked with us on this bill and is going to be a co-sponsor? And they just did the Elvis Act. Of course, in Minnesota, we have the Dylan Act and the Prince Act. No, I just made that up. But we do have people, as you know, who are fiercely, fiercely independent and protective of their incredible music in our state. But we have a common law in Minnesota that's helpful. There's like this state. Talk about, a few of you if you want to, just this need to have this national standard and why it's so important.
Maybe if I can
Okay,
chime in.
Mr. Kinsel.
I just want to comment on some of the things from before, which is, as someone who grew up without the First Amendment, I value it probably more than those who have, because I do not take it for granted at all. And it seems like it's well and alive in America, because half of the movies who were nominated for Oscars, were based on, existing folks. So saying that any, AI regulation that is respectful of the existing First Amendment is not reducing it, it's keeping it as it is, and it's alive and well. So I do think that we need to stay within the limits of First Amendment and not go beyond. As to national regulation, we work with global platforms. We're talking about global platforms, not even national. We're talking about global platforms. Doing anything state by state is a very cumbersome process. Twigs is content getting on a platform unauthorized. If we have to fight that on a state by state, it's untenable. It just doesn't work.
Mm-hmm. Very good. Mr. Davies, that will be my last one, and then we'll go ahead.
Thank you. I just need to reinforce what Robert's just said. Absolutely right. Music streaming is global. The success of this is having access to Twigs' music from the UK or from Tennessee or wherever. So it's high volume. Anything that adds complexity on a state-by-state level is anathema to this industry. So we're very strongly in favour of preemption.
Very good. Just the last thing kind of along those lines is, don't laugh, I heard you. It'll be very fast, and you can put it in writing of you, Mr. Davies. In January, we heard testimony that generative AI has been used to create unauthorized digital replicas of news anchors making comments. And we have a number of things going on in the journalism area. I have a vested interest. My dad was a journalist for the Minneapolis Star-Tribune, but also Senator Kennedy and I have the bill to push for negotiation of the content and to get them reimbursed, mainly from Google and Facebook for the use of this content, something that's going on in Australia and Canada, and I will not go on. But what steps can streaming services take to ensure that unauthorized digital replicas of journalists are not posted on the streaming platform?
Senator, if I could follow up with you after I'm not briefed on that.
Okay, excellent. Thank you.
Thank you, Senator Klobuchar. Back to Senator Tillis for his second
She had
round.
one thing.
Twigs, if you'd like to.
Yeah.
Oh, thank you. I'd actually like to go back to Mr. Scheffner's point about the desire to make very big and financially successful films about artists without consent. I think the problem is if you're able to use an artist's voice and likeness without consent about their life story, you're giving the impression that it's, I guess, the equivalent of a autobiography rather than a biography. And that's the confusion. If you're able to use my voice and my exact face, you're saying, this is what happened from my point of view. And it's not. It's what happened from a team of writers in Hollywood that want to over-dramatize things and maybe make it more tragic or, more fantastical. And I think that's what makes me really nervous and feel uncomfortable and very vulnerable. I don't think it's fair that even after an artist deceased, that somebody would be able, we can watch a film about a person, a star from the past, and if it's an actor, we know to take it with a pinch of salt. If it is the person themselves, then it just feels too unclear and not fair, and actually not in what am I trying to say? Not the best intention.
Senator.
Thank you, Mr. Chair. I'm going to be brief. I did have a question for you, Mr. Crabtree Ireland. The current draft legislation, individuals only have a right to license out their digital likenesses if they hire an attorney or they're a member of a labor organization. We've gotten some feedback that think that your organization in particular, that this is a giveaway. Can you give me other examples in law? A giveaway are really giving, vectoring everybody either into legal counsel or to your union. Can you give me examples, other areas in law where this is the case, where you have to engage an attorney or a labor interest to move forward?
Sure, and I guess I would just say I don't think it's just our union. It would be any collective bargaining representative. But there are a number of examples that occur in labor law, labor and employment law, where there are defined worker protections that then can be deviated from through a collective bargaining arrangement, but not through individual contracts. In this case, the proposal, I think, is a little broader, a little more open because of the option of securing individual representation by an attorney as an alternative. That's not normally present in those kinds of statutes. But I'm sure I could provide, I can't give you a laundry list right now, but I could provide
for the record, we're going to be submitting questions for the record for all of your, provide an opportunity for additional information. Mr. Chair, I just think it's remarkable if you take a look at the attendance of in the audience and the engagement from the members. You're hard pressed to see, I mean, on certain subjects, but on technical subjects like this, to have members go twice their allotted time demonstrates the interest of twigs. I'm going to end my questions with you. I do believe that Congress needs to act, but you need to understand that it's tough to get virtually anything done, even what appears to be common sense for the reasons that we've talked about. We're going to have constitutional questions we have to address. We have to get to a number of matters, and hopefully we do get it done this year. But you were, in your opening statement, you were emotional, or appeared to be emotional on one or 2 points. And I'm just trying to, I think that people need to understand, one of the reasons maybe you got emotional is because this is an existential threat to creators. And I'm trying to figure out how we educate people on the difference between an original creation from a human being and something that was either created or augmented from a machine. And this is more of a societal thing that we have to sort out. At what point is society just prepared to say, boy, this sounds as good, I know it comes from a machine. It's not. You mentioned something about the investment of your fans that they've made in you. How do you invest in a relationship with a machine? I mean, we're at an interesting point in time in history where we could have billions of people think the inauthentic creation of a machine is somehow as good as the hard work of a human being. I wonder at what point, that when we lose all the creators, this philosophical question, at what point can those machines never possibly match the creative genius of an individual?
Thank you.
That's okay. Red means on, which makes no sense to me. But
I think that there's two things here. I feel incredibly lucky to have spent the whole of my teenage years without a smartphone. So I straddle a generation where I memorized all my friends' numbers. I would walk to my friend's house. If we said we're going to meet at 1 o'clock, I just would have to be there. You know, that there was no texting and saying that I was going to be late. I loved my brain back then. I loved how simple it was. I loved what truth was back then. I loved that I was able to think for myself. Even where we're at with the internet now, it's so confusing. You know, even if you just want to find a simple news story, we can't. Even if you want to find the truth about, you know, whether a food even is good for you or bad, we can't. You know, it's just a stream of nonsense. I look at a lot of my friends that have children that are teenagers, and their mental health is really struggling. We're looking at young people that have anxiety, that have depression, because they're overwhelmed with information and lack of truth and lack of stability. And the thing that scares me is that my fans look to me for a North Star, a message, a sense of being. My work is something that they can find themselves in. And if you change the narrative of my work, we're just messing with their brains. You know, the solid essence of my work that I've spent 10 years developing, if someone can just take it and make up something completely different, I'd feel so bad because I'm harming people then, and there would be nothing that I can do about it. I think the way that we can prevent this from happening is putting the power in the hands of the artists, and also putting the power in the hands of people that are there to protect the artists, whether that's third parties like record labels or agents or lawyers. You know, that's up to the artist to understand and to, sign a contract if we want to. You know, but I think that the way that I've been experimenting with deepfake is going to help my fans. It's going to help them understand the nuance of my language across all parts of the world. Like, the way that I want to use it is not harmful, because I think inherently artists just want to express their emotions, be there for people, and say things that you can't say for yourself. So if you're putting words in our mouths, it's going to be devastating.
Well, I also agree. I'm very glad there weren't cell phones back when I was a young person. But maybe, I'm glad that we're taking up this bill. I do feel strongly that we should do everything we can to try and move it in this Congress. If not, then we just have to lean into it and get it done in the near future. But when we have these discussions, it points to all the other societal challenges of creators that we need to get right. This technology, I love it. I interact with generative AI for about an hour every day as a part of my own study of it, and a study that began back in the 1980s in artificial intelligence, for me personally. But we've got a lot of work to do, and Congress has a role to play. But we've got to be very, very careful not to overstep, not to trample the rights of others. And we're going to need your help and your continued engagement to get it right. So thank you all for being here today.
Senator Tillis, thank you. Thank you for, again, being a great partner. I have even more questions, but we have come to the end of our time, and you and Senator Blackburn have been terrific to work with. I am grateful to all of our witnesses for the way that you've brought your skills, your value, your background, your creativity, your voice to this hearing today. And we've engaged in a lot of different challenging questions about how we could refine this, how we could narrow it. There have been a lot of members who've participated. For those who did not participate, or those who still have other questions, the record will be open for questions for the record for the witnesses. They are due 1 week from today by 5 p.m. on May 7th, although, Twigs, in your case, 2 weeks, before we wrap this up with cellophane and move forward. If I could, today's hearing was important to show that when we regulate the use of AI, we have to balance individual privacy rights and First Amendment rights in a way that doesn't stifle creativity and innovation with these rapidly developing AI tools. It reinforces what we've heard today, why we need a clear policy to protect image, voice, and likeness of all individuals from unauthorized AI replicas. The feedback we heard and that our staff has received over the last 6 months is critical. I look forward to working with my colleagues and co-sponsors and the witnesses and the others who attended today to refine this in the next week or two and get to the point where we can introduce it next month, so we move from discussion draft to reality. I think we need to seize the moment, move forward. Thank you for your partnership. Thank you for your testimony. And with that, this hearing is adjourned.